what is essentially law? So is law something, so culling out from Article 13 as well, so is law something what the parliament decides or what the parliament enacts? Is it something what the judiciary interprets, or is it something what the judiciary comes out with, for example, the basic structure doctrine? What are your views on it, sir?
To your question, what is law? Law essentially was defined, if you were to understand it, as something that would guide the mores and guide society into a more structured, in a more rational manner, so that the rule of law, so that everyone would feel a certain sense of conformity, and that society can therefore be guided and taken forward in a more organized, in a more sane manner. So that's law. Now, law can be defined in many terms. You can define law as legislation through parliament. You can define law from the perspectives of case laws and interpretations to the judiciary. You can probably look at law from the perspective of its implementation. But having said all of it, I would say that law itself is something that impacts society, what society needs. So sometimes we have a top-down approach where we say, oh, the parliament does something that's law, or let's say the judiciary does something that's law. But I would say law is something that really helps to govern society of the people, by the people, and for the people. That to me is law. Now, how do we arrive at law? There are different ways of arriving at law. You arrive it through legislature, you arrive through judicial pronouncements. But law primarily is anything and everything. If you go back to civilization, when India really thought about how to go about life, law essentially came that how should we govern our society, our lives, our families, our positions, our institutions. That is how law really came about. Earlier, it was termed in terms of customs and traditions, which was basically through religion, marriage, kinship, family, the institutions of social life, which later on moved into constitution, and now we have a constitution which defines it. So I would say anything that is law, which governs life, that helps life to move forward, that provides structure and meaning, at the same time provides equality of opportunity, justice, and anything that Article 14, 15, 19, and 21 really stands for.
All right, sir. So it's more about the impact.
It's about society.
It's about society.
Yes.
Correct. So tying up the same, I think these fundamental rights, these human rights so well pointed out by the early freedom struggle, by the early freedom fighters themselves, who were, in fact, many of them were advocates. And therefore, many of them went on to become parliamentarians, to be politicians. So what do you think, sir? Many of the advocates going on to have a career in parliament, in politics, what is the driving force behind it?
You see, a parliamentarian is known as what? As a lawmaker.
Correct.
So when we say a parliamentarian is a lawmaker, and when you have an advocate who is been a student of law, is a practitioner of law, that kind of aligns together. So whenever, let's say, for example, there is a debate on a certain piece of legislation, that piece of legislation is being debated from various perspectives. Someone who is an advocate would look at it from a different perspective. Someone who's not an advocate may still look at it from an advocate's perspective, but probably the impact of the legalese or the fine print of how that legislation, when translates to subordinate legislation, might be impactful, is understood probably a little bit better by an advocate as compared to a non-advocate. So I'm looking at it from the technicality perspective. But that does not mean that in the legislature or in the parliament, more of advocates would really help. It does help, but at the same point of time, people from across the sections of society, whether you're a farmer, you're a doctor, you're a practitioner of any other discipline, every profession being represented really helps to the overall holistic improvement and quality inputs into legislation. Okay. So therefore, I would say that as an advocate, yes, it does help, because you can understand the perspective of a piece of legislation coming out as a bill, going to become a law in a much better light. And Parliament has seen, it has got many, many glorious traditions of great parliamentarians. You talk at Mr. Ram Jethmalani, you talk about various other leaders who have been there, have been part of the constitutional process through lawmaking. And even today, we have many illustrious advocates who are on the benches of the Rajya Sabha and the Lok Sabha. So I think being an advocate does help, and I believe that strengthens the process of lawmaking.
All right. So it does give you an edge.
It does, yes.
All right. Thank you for that, sir. And talking about how Parliament and again the Supreme Court, again the definition of law, must impact the society for good and must shape the society itself. So how can, in your opinion, the Parliament and the Supreme Court function and the courts itself function in a manner that it impacts the larger society for good, and how can they both contribute together so that there is betterment of the society?
You see, as we all know, that separation of powers is provided in our constitution. What essentially, Pranjal, it essentially means is, while we have the three organs of the process, which is the legislature, the executive, and the judiciary, and therefore the parliament, while has its own role, the judiciary has its role, and there is a separation of powers between both. Jurisdictions are different, approaches are different, and impact factor is different. I believe there are various measures by which we can have a common meeting ground, and I believe one of the common meeting grounds is the Parliamentary Standing Committee of Law and Justice. I've been a member of the Parliamentary Standing Committee on Law and Justice, where, let's say, for example, a piece of legislation before becoming a law goes through legislative scrutiny, just like the mediation law. It came to us, we debated, discussed over a period of time. It also helps because, you see, you can't really have a common ground where the Supreme Court judges and the parliamentarians are together, but the parliamentary forum, like the Parliamentary Standing Committee, provides for an opportunity where the Parliamentary Standing Committee can visit the Supreme Court, and there they can have an interaction on terms of where legislature comes from and where is the judiciary, and how to really bridge that gap, if any. And in terms of impact on society, I believe both the parliament and the judiciary are doing their respective roles well. And I believe it's more about engaging with each other. It's about understanding each other. There should not be any mutual trust deficit saying that the parliament is trying to do an overreach into the space of judiciary, or the judiciary is trying to be too activistic into the area of parliament. So while we are wary about that, at the same point of time, we should also understand that both these institutions have their respective roles and provisions. And I think together, working together, understanding each other, we can do better.
All right, sir. So for example, a judgment of Supreme Court, I think the government can help in the implementation bit, because then the whole implementation of a law comes into play. So how do you see that? The implementation of a law, the judgment is pronounced by the Supreme Court and the government helps in the implementation. How do you see that?
You see, whenever there is a judicial order, which is a judgment or otherwise, the government, so now we're coming to the executive, we're talking about the legislature, we're talking about the judiciary, now we're coming to the executive and the judiciary.
Correct.
So anything, let's say for example, the judiciary decides on a pronouncement of a certain decision, a writ of mandamus, let's say. And after a writ of mandamus, it is incumbent on the state government or the central government to undertake it. If it doesn't, then there is a contempt. So therefore, there is already a provision for effective implementation. And there is also a disincentive in terms of contempt, which actually drives the government or the executive to implement it. If it doesn't, then the chief secretary is hauled up before the court. In many cases, we have seen to actually talk to the court and tell why he did not implement it or his people did not. So we do have caveats like that. But having said that, I believe the executive is more and more wary and careful not to disobey the decision of the judicial writ that comes in. But in terms of sometimes the writs can be a little, like for example saying in the next 24 hours, all of this should be done by the government. Now that may not be at times very realistic, considering the magnitude of administration. So therefore that's where probably an engagement on the floor of the court between the judiciary and the executive represented by its counsel may be more meaningful.
Correct. So you talked about the contempt of court, so it can be a driving force as well. So we have seen in many cases, for example, there are huge time delays as well in the contempt of court proceedings. So how can we come to a common ground, the government, the executive essentially, and the judiciary, out of whether how to achieve a common goal of, again, serving the society?
Well, whenever there is a delay in terms of contempt cases, I think no government can afford to sit silent, because then it leads to an arrest or a warrant is issued. So therefore, provisions in law are very clearly laid out that if based on a contempt, the executive still does not take action, the judiciary would of course take action and issue a non-bailable warrant and probably bring them to a book. So that is one. But secondly, I believe that's a more punitive measure. I think the better way to do it is to ensure that we are alive to each other. When I say we are alive to each other, means the executive is alive to the judiciary, and the judiciary is also alive to the compulsions or the problems of the executive. So I believe we've had a There might have been aberrations, or at times there might have been exceptions, but usually the executive and the judiciary are on the same page, and especially because the officer of the court from the side of the government, the advocate general, or in the center, the attorney general and the solicitor general, are quite proactive in their approach. I think that really helps to provide appropriate decision making between both the executive and the judiciary.
Correct. So, and we talk about the impact of society, impact on society, as well as the final goal of law itself. And
right.
In the course that we held, you rightly pointed out that the impact on society must be catered to. Again, so the impact of society, so the judiciary should consider the public's opinion when it is making a judgment, it's making a verdict, it's passing an order, or should it be totally independent of it, just sticking down to the procedures, to the provisions of the law?
Well, I would suggest that, this theory that actually circulates that the judiciary should take into view people's opinion. I think the judiciary is not supposed to take into view people's opinion. The judiciary works on the perspectives of evidence. It works on the basis of the rule of law.
Correct.
It works on the provisions of the Constitution and its various aspects that leads to a certain harmonious society. You see, for example, at times emotions can run very high among the public relating to a specific opinion.
Correct.
So do we want the judiciary therefore to be swayed by public opinion? I would say no. I think we should be very clear in our stand not to get swayed by emotions. Because when you go on public or you talk to the larger population, there can be at times emotions that run high on one side or the other. And based on emotions and passions, judgments cannot be done. Judgment should be done and should always be done on the basic principles of rule of law and looking into the specific evidence or the matters that are at hand. So therefore, I would believe that the jurisprudence that has been drawn by our judiciary over the years, over the decades, is very strong. We have a very clear process that has been laid down by decades of very diligent jurisprudence and judicial orders, and I do not believe that public opinion should have any space in terms of deciding it. Otherwise, it can be dangerous.
Correct, sir. So, but for example, there's, again, as you said, there's a public emotion, there's a public sentiment going around, and that judgment can really result in a public order issue itself, and then huge riots can break about. So should the judiciary not consider it? Or
you see, the judiciary is always alive to a certain decision that they are taking relating to a larger decision that might have a law and order process. But I believe the judiciary is also mindful not to give in to public mandate or public opinion. Because if that's the case, then it will be a majoritarian rule. Then where is the rule of law? It's like there are 100 people here and 10 people here, and the 100 people are very angry about something, and the judiciary then gives them the favor. Then what happens to the 10? Then the rule of law completely fails. So the judiciary is alive to the fact that at times opinions among the public can be very high. It can be overwhelming. And as you said, in case there is a situation of a law and order, the judiciary takes into account that situation. And at times also, breaks down the decision making in a way that actually does not come out as a sledgehammer, rather like a scalpel. Slowly by slowly, it goes into the specifics of the matter and takes out the problem rather than sledgehammering it. So the judiciary is always alive, and I've always seen the judiciary being very sensitive to these issues.
Thank you, sir. And a last question. So how can we as law students, as students in general, contribute to the nation building process, to the society building process, and how can we contribute in the nationwide politics, in the nationwide impact?
You see, as law students, you have a great onus and a bigger responsibility because you learn so much about law and its other facets over the 5 years. So someone says you become a lawyer at the end of the 5 years. I don't think so. After the first year, you've got enough grasp of law. So what I would suggest is whenever there is a public opinion being generated, after you become a lawyer, then it's a different matter. But when there is a public opinion being generated on a specific aspect of law, I believe instead of just tweeting and Facebooking or things like that, why don't you write small blogs that provide certain aspects of law out to the public in a very simple manner? Because when someone who's already into a professional life or in a specific role in society writes or talks about it, people look at it from the perspective of that individual and say, oh, he is invested in this matter because of his role. But as a student, when you write about it, you put it up on a blog, you share it with your friends, share it on social media, it catches more impact. Because then what happens is you come in armed with the knowledge and the perspective of being a law student and what you have learned on law. Let's say basic structure doctrine. A lot of people talk about basic structure doctrine, but you have actually understood basic structure. You have done Kesavananda Bharati, you've done Shirur Mutt case. You can refer to that and say, as a student, this is what my understanding is. So therefore, many a times, whenever there is a public opinion, people like you, the law students, can actually put out facts the way they see it. So instead of probably getting swayed along with the entire population on the young crowd saying, hashtagging a certain trend, you can create your own perspective and your own understanding because you have a greater responsibility, because the custodianship of law also is there with you.
Correct. I think it can also promote the active citizenship within the country.
Absolutely.
And therefore the democracy itself.
Absolutely. You have a big responsibility.
Correct.